employment questions regarding the COVID-19 crisis we're undergoing. Welcome back to those of you who joined us last week, and welcome to those who are starting fresh this week with us. My name is Kyle Faraci. I'm the managing member of McGlinchey's Houston office and the team lead of our labor and employment practice group. I'll be moderating today's panel that consists of my fellow teammates that you see, Mag Bickford, Kathy Conklin, and Camille Bryant, all of our New Orleans office. As you see, we're practicing social distancing like the rest of the country, and this week we're even further distanced than we were last week, since that we're all adhering to our stay-at-home orders that were issued in our states and parishes and counties. So today we're going to discuss the guidance that we've received since last week from the Department of Labor on the Families First Coronavirus Response Act. We're going to discuss the essential versus non-essential employees, stay-at-home orders, and definitions of what isolation orders are under the Family First Act. We're also going to discuss some aspects of the CARE Act that was passed by the Senate Wednesday and was just now, about 20 minutes ago, approved by the House of Representatives, the $2 trillion stimulus package that President Trump is expected to sign very soon, likely today. Also, watch from us for some details coming soon on a webinar that we are going to host discussing key provisions of the CARE Act, specifically those that will relate to keeping your workers paid and employed, and how this impacts you under the Act. A couple housekeeping notes, just like last time, everyone's microphones are muted because as of right now, we have over 155 attendees. We received numerous questions from our attendees during the registration period, and we're going to attempt to answer as many as we can, and then also answer those that are asked during the seminar by using the Q&A feature at the bottom of the screen. If you have further questions after this webcast, or if we don't get to your question, please feel free to email any of us. Our contact information will be on the screen after the seminar is over. With that, we will go ahead and get started. Kathy, this law passed 20 minutes ago. Can you give us sort of a brief overview of what the CARE Act is and how it's going to impact the employers?
Well, there are many things in the Act that pertain to employers, but what I've mostly been focusing on is what's called the Paycheck Protection Program, which is the SBA loan to cover employers for 8 weeks of business expenses. And I will note that I looked at the law as it was introduced in the House this morning. There may have been some technical corrections made, so we need to look at the actual law as it passes. But what it basically says is that if you're a small employer, which means under 500 employees, you count by heads, full-time count as one, you do not count anybody who is an expat. There is an exemption for anybody who's in the food service industry, which is NAISC 72. Restaurants, they can count by location, and then also franchisees can count by location. But other than that, you have to look at your overall control group, affiliation rules apply. So if you're a small employer, basically they're going to give you an opportunity to get a grant for 8 weeks of your operating expenses. So you take out this SBA loan. The loan has to be taken out before June 30th of 2020. And you can use that loan for only limited purposes. Basically, they are mortgage interest on a mortgage that was already in place on February 15th, lease payments on a lease that was already in place, payroll costs, and utilities. However, the amount of the loan is capped. It's capped at basically 2.5 times your average monthly payroll expenses. So when you're figuring out the cap, you're going to ignore payroll expenses for anybody paid more than $100,000. But the first $100,000 you can count. And they have a pretty broad definition of what is payroll expenses to figure out. And there's a period of time where you average your monthly payroll expenses. And it includes the amount you're paying in healthcare, and it includes severance that you may have paid. It includes a fair number of typical W-2 items. So once you get that loan, if you want to have it forgiven, there's a complete and loan forgiveness provision, but there's a cutback, and there are two provisions in the cutback. one of the provisions is that if you have an employee, you look at your employees that you had in 2019 and you ignore anybody who earned more than 100,000. And they figure that by looking payroll by payroll. So somebody had one payroll period, which if you averaged it out would have paid more than 100,000 for the year, ignore that person. You can cut that person's pay. But anybody else, you're going to look at what you're paying them now. And if you're paying them, if you have the pay reduction of more than 25%, dollar for dollar, the amount that loan can be forgiven is going to be reduced by that. In addition, there's an overall look at your total workplace count. And this is on full-time equivalent employees. They're going to look at your average hiring back in two different periods. There's a period for basically the first half of 2019, or alternatively, you could take the first 2 months of 2020. You look at your average full-time equivalent employee count and compare that to your average employees in this 8-week covered period. And if there's a reduction, there's a fractional reduction of the loan that can be forgiven. That said, there's a rule that says if you can restore your workplace, the phraseology they use is eliminate the reduction. Those two reductions don't apply. And I will say, reading it, it looks like there's a lot of room for abuse in those provisions. It kind of looks like if you can count all the people and the amount you're paying them on February 15th and compare it to a date that is sometime between 30 days from now or June 30th, and you've eliminated the reduction in wages, or you've eliminated the reduction in the total number of employees, then this reduction doesn't apply to you. But I think there's going to need to be some guidance on that because it looks like there's a lot of loopholes the way that particular provision is written. And I'll tell you, the only thing that will get reduced, that will get forgiven, is an 8-week period. It's the expenses you pay in the 8-week period beginning on the date of loan origination and ending 8 weeks later. And it's only for those payroll, interest, utility, and rent payments that are both incurred and paid in that 8 weeks. So if you can satisfy that, you can get that money back. There are some other provisions that, for instance, for all employers, not just small employers, you can get a credit for 50% of the wages you pay to employees. It's up to $10,000 per employee. If you have more than 100 employees, that's only for people that aren't working. If you have fewer than 100 employees, you can get that even for working employees, but you can't take the SBA loan and be entitled to that credit. Similarly, what I saw in the law is there's a provision that gives you a delayed payment period for payment of payroll taxes. But if you get the SBA loan and it is forgiven, that delay doesn't apply to you either. So that's what I've seen so far. Of course, there's lots more in the Act. So there are many other opportunities for grants for SBA loans, but the Paycheck Protection is one I think that's going to appeal to most of the listeners today.
Thanks, Kathy. I understand there's also some provisions for unemployment compensation increases that are coming straight from the federal government once you apply through the state. I'm sure we're going to get more questions as we go today on this act, and I'll throw them back to you as we get them. Also, like I said before, we're going to host an entire webinar just on this act, so we should be able to get this information out to everyone who needs it. Mag, I want to turn to you. So I do want to discuss some of the guidance that we received from the Department of Labor. As you remember last week when we held this webinar, we couldn't answer all the questions. We were trying to say we're waiting on regulations, we're waiting on guidance. Well, the Department of Labor has not actually given us all the guidance we need right now, but they have answered some questions and given us a little bit. So let's, regarding the Family First Coronavirus Response Act, so let's turn to some of the guidance they have given us. What is, as an employer, like how do I count my employees? How do I know if I have less than 500? Have the DOL told us exactly how to do this? I mean, think about it. If I got, two businesses that are sort of related, but not really related, they're separate corporate formalities have been seen. How am I going to count?
That's a really good question. So we know that employers with over 500 employees private employers with over 500 employees are not going to be subjected to the act. But how do we know what that 500 is? The first thing we're going to look at, the number is going to be determined when the employee takes leave. Now, how I interpret that is if someone is taking leave effective April 1st, when the act goes into effect, then you count that number that day. But what happens if an employee takes leave a week later? I think that's going to be a rolling calculation to the best of my knowledge. They don't specify that in the clarifications, but that's what's implied. The other thing, it's going to cover full-time and part-time employees, but it looks right now not on an FTE basis, but on a per person basis. So you're going to have to count those numbers that way. It also includes employees that are actively on leave right now. So I had a client ask me about, what about my people that are on FMLA or pregnancy leave? They're going to count. What about temporary employees that are jointly employed between you and another company? Say you've got employees through a staffing company and you're deemed to be joint employers. Those employees are going to count. Also, to the extent that you use day laborers, i.e. people that are supplied through a temp agency that are not necessarily joint employees, they're going to be counted as well. So those are the people you want to focus on. Independent contractors are not included in the calculation. So you can take them and move them off the abacus, as it were. So what sort of things are we looking at to determine if we're joint employers or not? Well, a corporation, including its separate establishments or divisions, is going to be one entity. It's going to be a single employer, and all of their collective employees have to be considered. However, where there's a corporation that has an ownership in another corporation, that may tie in the calculations as well. They may be joint employers under the Fair Labor Standards Act, and all of their common employees have to be counted. So what you're going to have to do is, in that scenario, you've got to go look to the regulations under the Fair Labor Standards Act to determine if you qualify as a joint employer under that particular act. In addition, you're going to have to look at the Family Medical Leave Act to see who, in fact, are separate employers and joint employers. And they have a specific integrated employer test that you're going to walk through the steps to determine on that capacity as well. So it's a fairly complicated situation, but certainly one we can help you go through on a case-by-case basis, because that's really what's going to be the determining factor for some of our clients.
Great. Thanks, Megan. Just as a reminder to our guest, we will publish question and answer summaries after today's seminar, much like we did last week. So we're throwing a lot of material at you fast, but you'll be able to get this material from us. Camille, last week we were sort of struggling with this concept of 50 employees to 500 employees, and there was this assumption out there that it wasn't going to apply to 50 or below. But now we know that indeed the act does apply to all private employers with 500 or less employees. What if, though, I am an employer who employs less than 50 employees, and providing the sick leave or the expanded family medical leave would jeopardize the viability of my business as a going concern? It's going to put me out of business. I just don't have the cash flow to pay it. What relief do I have?
Yeah, well, we're still waiting on the precise guidance on exactly how to go about obtaining that relief. But what the DOL did tell us is that we know it's a dollar for dollar reimbursement. And so essentially what that means is that you are going to keep the employees' federal income tax, Social Security tax, and the Medicare taxes that you would typically be withholding from that paycheck. And so you're going to keep that instead of filing those taxes on a quarterly basis. You're going to be able to keep that revenue. And then if that's not sufficient to cover the leave that you would be giving to the employees, then the IRS is actually going to put forth an expedited process to accelerate those payments and those checks within 2 weeks. And so we still don't know what the details on that actually are, but that's expected to be announced next week.
And am I right that the Department of Labor is going to provide some guidance as far as how to apply for a hardship to exclude yourself from the act? And that's, we're waiting in the next week or two to get that?
Yes, all of that guidance is still we're waiting on.
Okay, good. So there should be some relief for our small employers out there. I'll stick with you, Camille, to ask you a question about the combination of sick leave and taking the sick leave, this first 80 hours. And the question is, can I take 80 hours of sick leave for my own self-quarantine and then another amount of paid sick leave for another reason provided under the emergency paid sick leave, such as I actually get COVID-19?
You can take the leave intermittently. In that specific scenario, I think it would be unlikely. If you have an employee that actually has COVID-19 and has that actual diagnosis, then you're going to want to make sure that that employee is self-quarantined for at least 14 days, and you don't want them to be in the workplace. So in that situation, they're only going to be entitled to 10 days or 80 hours worth of sick leave, and so it would cut off at that time. They don't get any additional sick leave outside of that 80-hour threshold. But what could happen is they could get the sick leave, come back to work, then all of a sudden maybe their daycare is closed or their school is closed, and then in that instance they may be eligible for FMLA leave. So they wouldn't get those first 2 weeks; they would still be unpaid. Then after that, they may be entitled to 2/3 of their daily rate, up to $200 for the FMLA leave.
Great, thanks, Camille. Mag, can an employer deny paid sick leave if the employer had already given sick leave to before April 1st, the enactment date? If the employer had granted sick leave then and was paying the sick leave then for one of the enumerated reasons, can they deny the additional 80 hours to an employee now?
I don't think so. From what we're getting in terms of direction, that doesn't appear to be the case. The law goes into effect April 1st, and that paid sick leave that's provided under that law needs to be paid on or after that date. So I don't believe it is. And unfortunately, people got sent home, significantly before April 1st. But if you want a tax credit, you're going to have to do it after that date.
Thanks, Meg. Kathy, I'm going to ask you a burning question that a lot of our clients have. With regard to the sick leave, and Camille, I may ask you to chime in on this as well, too. The sick leave language differs from the emergency FMLA language in that it requires the issuance of an isolation or quarantine order for being the reason that you are out. Does quarantine mean stay home orders that we received from the governor of Louisiana, or the one I received in Harris County from our county commissioner? Is that stay home order a quarantine order?
Well, actually, I'd like to pass this over to Camille because we were discussing this morning. The questions and answers in the DOL seem to narrow the circumstances in which an employer can be forced to give this paid leave and thereby limit the circumstances when they can get a credit, because it was only available if the employer was able to work, but the employee couldn't work because of an order. Camille, would you like to elaborate on that? I think that answers the question because it really is looking as though it's an individual employee by employee analysis, not an overall workforce analysis. Camille?
It really is an individual analysis. And, we looked in depth specifically at the Louisiana order because that's what's impacting us locally. And in that order, we determined that the governor actually issued it based upon his ability to issue a quarantine order. So that order in and of itself is a quarantine order. But the way that the DOL has sort of answered some of the frequently asked questions, they seem to suggest that if your employee isn't working because the work isn't there, then they're not going to be entitled to leave. So if the employee is furloughed or if the employee is just simply terminated, whether it's before April 1st or after April 1st, they're not going to be entitled to leave simply because they're unable to work because you just don't have the work there. And so the act wouldn't typically apply in those instances.
Let me ask you, Camille, with regard to the act, both the sick leave provision and the emergency family leave provisions require or have a carve out for unless you can telework. So if I'm capable of working from home, can I not get the sick leave, or can I not get the emergency FMLA leave?
Yeah, well, actually, as we interpreted the act, the telework provision really only applies to FMLA leave. And so if the employee is unable to telework and they're specifically unable to telework because they're at home taking care of a child, then they're going to be entitled to that leave. The sick leave provision, as I recall, doesn't necessarily have that language with regards to telework in there, but rather there are 6 different reasons why they may qualify for sick leave. And so you're going to have to go on that analysis point by point to determine whether or not the employee falls within any of those caveats. And the employee does have to actually document and provide you with documentation of their need to take that leave and their justification for that leave. And if they don't do that, the IRS has actually issued some guidance on that. You may not be entitled to that tax credit if you can't substantiate the reason that leave was taken and that it was justified.
What about the situation where your office was closed for one of the stay-home orders, and so thus you are now at home, but you're also at home with a child whose school was closed, but your spouse or daycare keeper or other child care provider is at the house? Can you still take advantage of that leave if you have child care in place?
Yeah, I mean, I think this is honestly, it's really a tricky one, but I think you have to pay it. I mean, under the act, as long as they can establish that they're at home, they're not able to telework, and their child's school is closed, then they're entitled to that leave. And I think that the problem that you're going to have is actually policing that. How do you know that the other spouse is actually taking care of the child, or that they're not doing something else inside of the home? So I think you would have a really hard time trying to prove or disprove that employee's theory of whether or not they're actually capable of taking care of their child or not.
Great, thanks, Camille. Let's turn to some specific questions that we've received from our registrants. And sorry, guys, I'm going to bounce around a little bit with you here. And some of these I'm going to try to interpret as best I can to provide for the greater good of all attending. Okay, so the first question here, Mag, is I'll shoot it to you. Can we pay employees a weekly bonus based on the number of days worked that week? The goal being to provide incentive to work if possible, so pay leave is only used by those who really need it.
The easy answer is yes. And in fact, I think if you can afford it, it's a very good idea actually to bring people into the workforce. But I do want to caution our attendees, if you do that, you will have to consider that pay as part of an overtime rate. It will also go into the calculations with regard to the rates under the Families First Act. So yes, you absolutely can, but you're going to have to consider that as part of their rate of pay for other calculations.
Great, thanks, Mag. Let me scroll down here to Camille. I'll catch you on this one. So this company has 12 employees, and they are set up to work remotely, but none were working remotely before. We're all in this sort of situation now. Since all employees have the ability to report to work remotely, do they still have the option to go on paid sick leave or FMLA leave under the Act?
So the employees would still be entitled to go under and get sick leave. They would not be entitled to FMLA leave because they have the option to telework. But if they start having symptoms of the virus, if they're diagnosed with the virus, if they're caring for someone else that has the virus, then all of those are qualifying reasons for paid sick leave, and they would be entitled to sick leave in that instance.
Thanks, Camille. Mag, I think this might be a softball for you. And we may have discussed it before, but can we get reimbursed for employees taking leave prior to April 1st?
No, we can't. So it's that simple.
Well, that was a softball to you.
Yes.
Kathy, I'll come to you, and we're going to jump back just a little bit to the CARE Act. We had a question that came in during the seminar. The question is, with the new stimulus package concerning unemployment benefits covering furloughed employees, are furloughed employees eligible for company health insurance while receiving the unemployment benefits?
Depends on your health plan. I have not read the CARES Act provisions. If there's something in the CARES Act that mandates that the employer continue to pay the healthcare costs, such as if it was treated as FMLA, I am unaware of that. But under normal circumstances, you have to look at the terms of your plan document, make sure that employees who are not working are still entitled to be covered, even though they are no longer working 30 hours a week.
Thanks, Kathy. Camille, we discussed before the employers under 50 and how they may get some relief, but we also got some guidance from the Department of Labor regarding posting notices. I think we received that yesterday or maybe late Wednesday night. So if an employer owns a company with 20 or less employees, are they exempt from the law? And two, are they exempt from the notice posting requirements?
No private employer that has less than 500 employees is exempt from the law as of today. Until the Secretary of Labor actually issues some regulations specifically excluding certain people or certain sectors, then everyone has to comply. And so they would still have to post the notice in that instance. And the guidance says that you're supposed to post it in places that are where notices are typically posted. In light of sort of the certain times that we're in, we would advise emailing the notice, which they've also said that that is an acceptable way of sort of getting that information out to your people.
What about providing the notice if you have a multilingual workforce? I mean, do you have to provide this notice in different languages?
You don't, according to the DOL, but I think you really need to look at it state by state. For example, California, if you have a certain percentage of your population that speaks Spanish, you have to translate that under California law. So you're going to want to make sure, depending upon where you are, whether or not there's a state requirement, but the DOL specifically is saying that that's not required.
Okay, I did notice on the DOL's website today, on the Wage Hour Division's website, that they did issue one in Spanish. So that may be available for those of you who have a multilingual or high Spanish speaking workforce. You may want to issue it both in English and Spanish if you can, just so your employees do understand what their benefits are and complying with the spirit of the law. Kathy, I'm going to come back to you and ask you a specific question here. It says, most of the guidance that this company has seen either relates to the Family First Act or the CARES Act has been related to individuals who are actively employed or to small businesses. Are there any forms of relief or assistance being made to those available to retirees beyond the cash stimulus payments?
None whatsoever. No. I think the point of the law is to get working people back at work and to give the relief to employers. So there's no relief for retirees.
Okay.
Now, I will say there are some retirement plan provisions, though, that if you're retired, there are some tax provisions. Shall I run through those?
Sure.
In the new law, if you wanted to take a loan and the loan limits used to be $50,000, it's increased to $100,000 for COVID-related loan purposes. Similarly, there is an exemption from the early distribution tax if you're under age 59 and a half. If you take out a COVID distribution that is no more than $100,000, you're exempt from that tax. If you take that money, you can either pay the income tax over 3 years, or you can pay it back within the third year, and then it would be treated as though you took a 60-day rollover and gave the money back within 60 days. So you don't have any income tax on it then. If you're a retiree and you're receiving required minimum distributions, those are suspended for 2020. And if you're an employer that has contributions to a pension plan, there's some relief for making those contributions in these times.
Okay. Kathy, let me stick with you because Camille touched on this issue earlier with regard to how employers get the money back from the FMLA leave or the sick leave. So can you just walk us through like how do they recoup these expenses exactly? Because luckily, a lot of our friends on the line today use payroll companies who have likely gone through this. But I will tell you, I've been in contact with various payroll companies this week who also don't know exactly how this is going to work. Can you kind of walk us through it?
Well, the IRS came out with guidance on March 20th, and they promised that they'd issue a form this week, and it doesn't look like they're doing that. But we were of the impression that they were going to be able to get the credit for some of the leave already granted. That is not the case. So you're only going to be able to get the credit for these special leaves that are paid on or after April 1st. So I think that's giving the IRS a little more time to come up with the form that you need. But what they basically said is, okay, when you're paying the money to the employee, it is exempt from FICA. not from the Medicare tax and not from income tax withholding. That payment, though, is exempt from FICA. So you pay it to the employee. All your other wages, they said, including withheld income tax, you basically can just short the amount that you pay into the government equal dollar for dollar to the amounts that you're paying in these extra leaves, plus the healthcare costs that are associated, plus the Medicare tax that you pay on those payments. So, but I do think they're going to want a form, and that they are going to issue a form. So if you just short your payroll taxes right now, there might be some questions on reconciling that later.
Okay, thanks, Kathy. Mag, I haven't picked on you in a while, so I'll come to you for a few questions here that I think are right up your alley. So are there any restrictions on terminating employees during the pandemic, so long as they're not subject, the employer is not subject to any Fed or mini WARN Act or regular WARN Act or any mini WARN Act requirements?
Well, all the other laws still exist, right? So yes, there are limitations on terminating people. We have to make sure that we comply with Title VII and the ADA and FMLA with regard to other kinds of leaves and state law, and the list goes on and on. So yes, there are certainly limitations. And when you do decide that you need to let go of someone during this time, you need to take all the precautions you would normally take. Don't think that those are just forgotten about, even though that seems to be forgotten about right now. So that's really important. But other than that, if you can follow those other laws and you need to terminate someone, you can do that. And you want to take the same cautions and precautions that you would do at any other time before COVID-19. So you want to be sure that. One thing that I should call to your attention is that the Family First Act does have a retaliation provision, but it's very narrowly drawn. I was surprised by the language because it says, in effect, you can't retaliate against someone for taking leave or attempting to take leave. So, one of the things we struggled with initially was what do we do if we know we can't afford the provisions of leave? Can we start terminating people? Things are still fleshing out, but it looks like if you have an economic necessity to let people go, or a behavioral or disciplinary necessity for letting them go, you can certainly do that. Last thing that I want to throw out there is union contracts, because as I mentioned in our last conference, they still govern, they aren't going away. And to the extent that you have employees covered by CBAs, you're going to have to follow those rules as well. Last but not least, don't forget your employment agreements, right? Because some of your employees may be covered by those agreements. And that's a fairly complicated question on what to do with those agreements, because if they have a force majeure clause or an act of God clause, as we call it, you might be able to get out of some of the obligations. But again, you want to have a lawyer look at that before you just take that position cavalierly. Otherwise, employment agreements are going to count.
That's good advice. Thanks, Mag. What about sticking with you? So I want to know if an employer does plan on laying off or furloughing employees right now, before April 1st. And they're going to do that to some employees that are already at home because of whatever various stay home order has been issued, whether it's the New York isolation order or the governor's order in Louisiana or the various county orders throughout the country. Are those employees going to be eligible to take advantage of the Emergency Sick Pay Leave Act?
That's not a softball. Certainly they're covered by the Act right now and are entitled to the distributions under the Act. But if you're no longer employed, then I don't think you're going to qualify for those provisions. I do think, going back to my last point, you need to be really careful in that scenario that what you're doing is not construed as retaliatory for them taking leaves under that act.
I think you're right. If they're not actually employed on April 1st, then they're not going to get the notice, and then they're not going to be entitled to take the leave. But we do have to be careful with any kind of potential retaliation claims that we may see out there. My advice on that, and I think, Mag, we've talked about this a little bit, is make sure you're documenting why people are being laid off, why they're being furloughed, why they're falling into the group of folks. If you're not doing an entire workforce, if you're doing portions of workforce, last in, first out, whatever it may be that you're using to determine which employees are actually laid off, document it so that when those suits come later, we can easily say, no, they were involved in a layoff based on these economic reasons, and they were chosen for X, Y, Z.
Mm-hmm. Some employers in that scenario may choose to give severance packages. Mm-hmm. And in that scenario, as I've said 1,000 times, don't give something away unless you get something back, which is the basic tenet of a severance package. You want to make sure you get the releases under that are available in a separation agreement or severance package, whatever you want to call it. And the other thing I would caution you about is don't ever forget the Older Worker Protection Act that's going to cover some of those people who may be severed. And that has certain requirements for individual separations, but it has more onerous obligations when there are more than one person's involved. So it's likely you're going to see the applications of the Older Worker Protection Act in a multiple person scenario come into play, which means that you have to follow the language in very close detail of that statute, and that people have a longer time to decide if they're going to accept the severance.
Great point on the Older Worker Benefit Protection Act. That is still applicable to this situation. And that would certainly get us into that April 1st date on which the act takes place. Of course, if you're not providing any severance package, there would be no requirement to extend, they're just laid off, right?
They're just laid off.
Yeah.
One thing, just as an aside, remember, all those other laws apply. So if you're letting go of people, I think you still ought to do a disparate impact analysis of the group, because, we may lay people off, and if it's all the women, for example, or everyone over 40, or a great majority of them fit in protected classes, you may end up with a Title VII disparate impact case down the road.
Thank you. Kathy, let me ask you a question that came in from one of our attendees about someone who's working remotely. I'll give you the hypothetical of, it's a Louisiana employee who was told, you got to go work remotely because of this stay home order, and they are working remotely from Mississippi. At what point do we have to consider whether we pay unemployment benefits / workers' comp under Mississippi's rules versus Louisiana's rules?
Well, I did take a look at that last night. Thankfully, somebody sent that in advance, so I was able to research it. And so far, I've seen absolutely no relief from the normal laws, which is if the person, you determine which state laws apply by where the work is being performed. So unfortunately, as of the current point of time, I think that person is a Mississippi employee in that scenario. But, given the fact that we're in an emergency period, I'm not so sure that, Mississippi is looking for those laws, but I think that if you can comply and line them up as a Mississippi employee, you're in better standing in case there is unemployment comp, a claim that needs to be made. I guess if their iron falls on their head, I think that the state law applies where the work is being performed.
Okay, thank you, Kathy. Camille, let me ask you, are there any carve-outs for doctors, nurses, healthcare providers from this? I mean, if they are all out on family medical leave, we'd be in a tough spot. What kind of relief will we have for these folks?
Yeah, this question has actually come up quite a bit recently, sort of about, coverage for certain healthcare workers. And what the Act says is that the Secretary of Labor has the authority to issue regulations excluding healthcare providers from the FMLA provision specifically. The Secretary of Labor hasn't yet issued those regulations on that topic. So as of now, they're still covered under that. But under the sick leave provisions, the employer has the right to determine whether or not they're going to actually offer sick leave for certain healthcare providers or emergency responders. But then the issue becomes, well, who's a healthcare provider and who's an emergency responder? And we don't actually have any guidance on that. If you actually look at the FLSA's and the DOL's previous regulations on that, healthcare provider has typically been identified as someone that has a licensure. So whether it's a doctor, a pharmacist, a social worker, those people. Some of the commentary now is sort of trying to broaden that definition because we are in this sort of a very heightened emergency state and essentially trying to qualify anyone that's in the healthcare system as an emergency responder. I don't know that the law is gonna actually go that far when we get to the regulations. But if you are someone who is a healthcare provider and you don't wanna have to pay out sick leave, sort of the more conservative approach would be to stick with the current definition of a healthcare provider, which would be those people who actually hold that licensure. And then sort of your other people who would be your support staff, you know, your billing people, those sorts of people, they would still be entitled to that sick pay.
Great, thanks, Camille. Kathy, I want to ask you a couple questions, and these came in today during the seminar. So if we don't know the answer, we'll definitely look it up and come back to our attendees with this. But one of our attendees wanted to clarify, if someone is making over $100,000 but we have to reduce them over 25%, is that counted against them? Is the employee still counted?
Nope, you can reduce the high paid. You can cut them to zero. That won't impact you. They're only looking to protect the pay of people who typically are paid under 100,000.
Okay, great. Now, what about would the SBA 8-week loan forgiveness impact payroll tax credits under the emergency FMLA guidelines?
No. Well, you cannot double dip. There are double dipping rules saying that if part of the payroll cost that you're trying to be reimbursed for under the SBA loan, you've already been reimbursed for under the credit, it doesn't count. But you can do both. Okay,
thank you. Mag, I'll throw one to you that came in today. Can an employee refuse to go to work based on their age, presumably because they are in more potential to contract virus than younger, although we're seeing now that really no one's immune from this. So, but can they refuse to go to work because of their age?
No, they can't. Right now, fear factor is not a viable basis for refusal. They would have to either get some sort of quarantine provision from their doctor because of their age or something of that status. Otherwise, they would have to go. And by the way, we're seeing a lot of that, right? We're seeing, people in essential businesses who the employees are scared, understandably so, and they don't want to go to work. But no, they have to go to work.
Thanks, Camille. I'll give one to you. I'll give a couple to you actually here. So, what if hours worked have been cut across the board just due to a reduction in services that are required? Are you still required to pay 2/3 of the original salary under the FMLA to someone who takes the leave?
Well, it's going to depend. I mean, if it's someone who's a salaried employee, they're presumed to work 40 hours. They get 2/3 of whatever their agreed upon salary is. Mm-hmm. If it's someone who's a part-time worker, then you're going to look at what is their average hours worked and their average hourly rate over a 2-week period. So if their hours were cut during that 2-week period, then you would take that into consideration and that would factor into their 2/3 calculation.
And let me ask you this question also, and maybe Kathy may comment on this as well, but this may be in your purview. I've got an employee who's been on unpaid extended leave since August. Is that employee going to be entitled to any benefits under the FFCRA?
This is something that's been debated back and forth quite a lot, is whether or not this act actually extends the leave provisions and give you 12 additional weeks, or whether it just gives you another qualifying reason to take the leave. We have been of the position that it is the spirit of the law is to give people leave another 12 weeks specifically for this reason. But there's a lot of commentary out there saying that it doesn't give you another 12 weeks. It's only just another qualifying reason to take the leave. So hopefully, we'll get the regulations on that before April 1st. And I know that there have been questions that have been posted to the DOL asking for guidance on that specific issue. So hopefully we'll know specifically the answer to that before the 1st. So Kathy, I don't know if you have anything to add to that.
Now, as you know, we had discussed this quite a bit, and the way the law was written was this new provision was just a new reason for FMLA leave plopped into the normal FMLA provisions, which leads you to believe if you've already exhausted your 12 weeks, you don't get more. But I agree. Well, let's see if the DOL can give us further guidance on this.
Great. Kathy or Camille, whoever's left unmuted, we keep waiting on more and more regulations from our interpretation from the Department of Labor. And one we discussed earlier was going to be for healthcare providers. But a specific question came in that piqued my interest. And Camille, what do you think about this? If it's, and this is a total opinion, if you run a physician's office, not within a hospital, but you're just providing primary care to the general public, do you think that type of healthcare will be exempted? Or do you think that's gonna be separate from those who we need to be working emergency rooms, working in hospitals, caring for those who are more impacted?
I mean, I think it's both, because the way that the law is written, it says a healthcare provider or an emergency responder. So I think it includes both classifications of people. And so I think if it's just, a physician's office that decides that they don't want to pay out sick pay, I think they have that right. And I also think it's because, we have our hospitals overloaded. And so we still need to make sure that we have our regular doctor's offices that are still open and able to take in patients so that we don't overload our hospitals.
I completely agree.
Okay, I think you're right. I think we're going to hopefully get more guidance from the DOL in regard to non-physicians and pharmacists, but home caregivers and those who are providing vital services who have to go to work each day to care for those who may be most affected throughout the country. Okay, so with that, we are going to be ending at 1:50 today, and I appreciate everyone's attendance. We do have several other questions to be answered, and these will all be answered through our question and answer memo that we'll publish hopefully early next week. If your question wasn't answered, or if you have additional questions, please feel free to send those to us, and we'll be happy to respond as quickly as possible. I do thank everyone again for attending today. The response has really been great. To the extent there is more need and more regulations that come out, we're going to keep holding these webinars to provide you with the most up-to-date information. Also, please go onto our website at www.mcglinchey.com and look at our COVID-19 resource pages. There is information there, not just from the employment perspective, but from financial services, real estate, business industry in general, that can help you with a lot of the questions you may have regarding how we were responding to this pandemic. Again, thank you again for attending. Please be well, stay well, and thanks for being part of the McGlinchey family.